The case that I'm going to be discussing is R.A.V. versus St. Paul. In this case, in the early morning hours of June 21st in 1990, a group of white teens erected a cross and they set it on fire in front of an all-black family's home, in the front yard of their home, in an all-white neighborhood. This family was new to the neighborhood, and apparently black and white has still been an issue in St. Paul. All the people who are involved are an unidentified black family whose name had been withheld for protection purposes, as well as the fact that in this case, the state took up the case and not the family. The second party involved was several unidentified teens, who were unidentified by name, but identified by the acronym R.A.V. Also, the city of St. Paul was involved, as well as their ordinance against crime. There were several laws involved, and there were several laws that could have been involved. The laws that were involved were hate speech, the free speech clause, which was basically saying that everyone has the right to freedom of opinion, but not everyone gets that, which everyone should. Also, the St. Paul bias-motivated crime ordinance was involved, and that ordinance basically made it so that in this case it was a misdemeanor to place on public property or private property a symbol, object, appellation, characterization, or graffiti of any sort, including but not limited to the burning cross that was placed in the family's front yard. Also, it included a Nazi swastika, which one knows or has reasonable grounds to know arouses anger or hate or alarm or resentment in others on the basis of race, color, creed, religion, or gender. And that was specifically from the book. In this case, there were a bunch of laws that weren't used that could have been used. It was noted that laws such as Minnesota statutes against terroristic threats, arson, criminal damage to property, all of those laws could have been used, but the prosecution chose to use the St. Paul ordinance. The teens were ultimately convicted under the St. Paul crime ordinance, but the trial court's decision it was basically dismissed on the belief that the acts performed on that morning of September 21st, 1990 were supported by the First Amendment, and that the ordinance was far too general and far too broad to put a pinpoint on exactly what fighting words are or what is and isn't allowed under the First Amendment, basically. After the trial court's decision, the Minnesota Supreme Court basically reversed the decision and wanted to have a trial, while the U.S. Supreme Court reversed the decision of the Minnesota Supreme Court. The U.S. Supreme Court basically reversed the decision on the ground of the disagreement of the ordinance being legit. It basically thought the St. Paul crime ordinance was unconstitutional because it didn't include all forms of fighting words, which is not allowed under the First Amendment. The U.S. Supreme Court's ruling was brought by Justice Scalia and about 4 other members who all were in concurrence, and they all felt that the St. Paul crime ordinance was unconstitutional because it didn't include all forms of fighting words. The result of this ultimately was the reversal of the court's decision, which overturned the conviction of the teens, which means everybody basically got off scot-free for this hate crime, basically. And it also struck down the St. Paul crime ordinance, basically made it obsolete. They don't use it anymore. And in my opinion, I feel like there are the other laws that could have been used weren't used because of how wobbly the St. Paul crime ordinance was, and the fact that it didn't really stand a chance against the First Amendment at all. And the Supreme Court justices and the prosecutors, they knew this. And that is probably why they did not use any other clear-cut laws that should have been used, like arson. That, you know, that's pretty much it.